Good morning and welcome. I'm Karen Cross, Chief Executive Officer of the Greater Kingston Chamber of Commerce. For business owners, the pandemic is proving to be one of the greatest leadership tests of our careers. Not only must you protect the health of your employees and your customers, you must also navigate far-reaching disruptions to your operations, plan for recovery, and prepare to reimagine your business model for the next normal. In this challenging context, the task of fostering equality, diversity, and inclusion can easily take a back seat. That said, we cannot forget that EDI is a powerful enabler of business performance. Companies whose leaders welcome diverse talents and include multiple perspectives are likely to emerge from this crisis much stronger. Today's presentation will provide an overview of EDI in the workplace to ensure you stay compliant within the human rights codes and hopefully serve as a reminder the importance of creating a long-lasting, inclusive workplace culture. Now I'll pass it over to Jessica to say a few words.
Perfect. Well, thank you so much, Karen, and good morning, everyone. My name is Jessica Colvin, and I'm the Manager of Business Development and Member Services here at the Chamber. So we have a very exciting presentation planned for everyone today, but just a couple things to note before we get started. Today's session is being recorded and will be available on our YouTube channel later this afternoon. We have also allotted time for Q&A at the end of this session, but encourage you to enter your questions in the chat as we go along. We are very proud to once again partner with Pro Bono Students Council, Queen's University chapter, to provide law students with rewarding opportunities to volunteer on projects that align with their skills, experience, and education, with the aim of promoting greater access to justice in our community. Now, I would like to pass things over to Bhavika, JD Candidate 2023, Queen's University, Faculty of Law, to begin today's presentation.
Good morning, everyone. I'm just going to share my slides. But yeah, so I think we're good to go. Peter, you can begin.
Sounds good. Thanks, Bhavika. So good morning, everyone. My name's Peter. I'm here with my colleagues, Bhavika, Rawson, Charlotte, and Nicole. And we're student volunteers from Queen's Law, part of Pro Bono Students Canada. And today we'll be presenting on diversity, equity, and inclusion in the workplace. So just as a disclaimer, this presentation does not contain legal advice. Pro Bono Students Canada is a student organization. This presentation was prepared with assistance of PBSC Queen's Law student volunteers. PBSC students are not lawyers and are not authorized to provide legal advice. This presentation contains general discussion of certain legal related issues only. If you require legal advice, please consult with a lawyer. So to begin, we're going to start with the Ontario Human Rights Code. So it is the business operator's responsibility to ensure that their employment and service practices are in line with the Ontario Human Rights Code as a matter of protecting their own business against claims. Canada human rights law stems from the Universal Declaration of Human Rights, which was drafted by the UN in 1948. It sets out fundamental human rights to be universally protected. The first two articles are about equality and freedom from discrimination, the foundation of the Canadian Human Rights Act. In Canada, human rights are protected by federal, provincial, and territorial laws. The Canadian Human Rights Act of 1977 protects people in Canada from discrimination when they are employed by or receive services from the federal government, First Nation governments, or private companies that are regulated by the federal government, such as banks, trucking companies, broadcaster, and telecommunications companies. Similarly, the Charter protects every Canadian's rights to be treated equally under the law. It only applies to governments and not private individuals, businesses, or other organizations. As such, this means that for the most part, a person cannot mount a charter challenge against a private business, a private organization, or a person who is not acting on behalf of the government. The relevant legislation that applies to private businesses are provincial and territorial human rights laws, for example, the Ontario Human Rights Code, which are very similar to the Canadian Human Rights Act and apply to many of the same principles. They protect people from discrimination in areas of provincial and territorial jurisdiction, such as restaurants, stores, schools, housing, and most workplaces. I'm now going to pass it over to Rawson to go over it a bit more in detail.
So the code sets out basic rights and responsibilities, and then also how it should be interpreted and applied, along with providing a role and the structure of the Ontario Human Rights Commission and the Human Rights Tribunal of Ontario. The code also specifies how the Human Rights Code has primacy over other provincial legislations. There are 5 protected spaces under the Human Rights Code, which are accommodations, as in housing, whether you're buying or leasing, contracts, employment, membership in unions, as well as goods and services, which include stores, restaurants, public areas like malls, and so on. And then some of the grounds that we can highlight here are gender identity, place of origin, disability, receiving public assistance, family status, etc. And an example of these protected grounds even encompasses the hiring process, including job advertisements or application forms. An ad saying an employer is looking for certified welders with Canadian experience may be deemed discrimination because it could exclude welders who have qualified experience outside of Canada. This would be called direct discrimination since a policy or rule specifically targeted individual persons. Or in interviews, it might be deemed inappropriate to ask questions like, where are you from, specifically when it does not pertain to the job profile. If an individual who falls within the protected categories claims that they require an employer or service provider to make the changes to their ordinary practices as a result of the individual's protected characteristic, the employer and the provider has an obligation to engage in a process called accommodation. Broadly speaking, accommodation involves a review of whether established policies and practices can be adjusted to facilitate the individual's request without undue hardship. Accommodation is necessary to ensure that people have equal opportunities, access, and benefits. Here, the test is not whether it is impossible for the employer to accommodate the employee's characteristics. The employer does not have a duty to change working conditions in a fundamental way, but does have a duty, if they can do so without undue hardship, to arrange the employee's workspace or duties to enable the employee to do their work. Therefore, the rule is that a cause for potential accommodation must be adopted in good faith and be rationally connected and reasonably necessary to the functions being performed, meaning that the rule or standard itself must be inclusive and must accommodate individual differences up to the point of undue hardship. To claim the undue hardship defense, the organization responsible for making the accommodation has the onus of proof. It is not up to, for example, the person with the disability to prove that the accommodation can be accomplished without undue hardship. In many cases, it will not be costly to accommodate someone's mental health issue or addiction, for example. Accommodation may simply involve making policies, rules, and requirements more flexible. While doing this may involve some administrative inconvenience, this inconvenience by itself is not a factor for assessing undue hardship. The factors that are considered are costs, outside sources of funding, and health and safety requirements. The nature of evidence required to prove undue hardship must be objective, real, direct, and in the case of cost, quantifiable. The organization responsible for accommodation must provide the facts, figures, and scientific data or opinion to support a claim that the proposed accommodation, in fact, does cause undue hardship. A mere statement without supporting evidence that the cost or risk is too high based on impressionistic views or stereotypes will not be sufficient. Now looking at the factor of cost, costs that remain after all the costs, benefits, deductions have been considered will determine the undue hardship factor. All projected costs that can be quantified and shown to be related to the proposed accommodation will be considered. It is important to note, however, that mere speculation, for example, about financial losses that may follow the accommodation of a person with a mental health disability or addiction, for example, will not be generally persuasive. Where an accommodation would cause undue hardship, the accommodation provider is expected to consider whether a lesser form of accommodation would be adequate. For example, providing an interim accommodation while the organization establishes a reserve fund to phase in the accommodation that is actually the most appropriate. Therefore, the costs must be excessive or disproportionate in order to amount to undue hardship. The next two factors are funding. And before being able to claim that there has been undue hardship based on costs to accommodate someone, an organization would have to show that they took advantage of any available government funding or other programs to help with such costs. An example is a tenant in a supportive housing building in a street level has post-traumatic stress disorder, which is exacerbated by exposure to noise. The person requires soundproofing of their apartment to accommodate their disability. To make the accommodation, the housing provider applies for funds and the tenant accesses a government-funded accessibility grant for people with disabilities to help alleviate these costs. The third factor here is health and safety. Accommodation provider will be required to conduct an analysis which takes into account the risk of the health and safety consequences against the benefit to the individual requesting the accommodation. These risks need to be real and not speculative. Each circumstance is specific and will involve a different set of factors. For example, the behavior of a woman with schizophrenia had the potential to endanger the safety of other tenants in her building. For example, on several occasions, she screamed loudly in the halls and other common areas, and once she left food on the stove unattended. By working with the woman and members of her family, a housing provider was able to develop a crisis response plan, which involved the woman's brother and mother being available by phone and being willing to intervene when her behavior was disruptive. This just shows that zero tolerance policies will often have a disproportionate impact on people with mental health disabilities or addictions, and they therefore do not negate an organization's obligation to accommodate to the point of undue hardship by assessing and reducing risk. Apart from providing accommodations to the point of undue hardship, the code expects workplaces, services, housing, etc., and expects them to be free from harassment and a poisoned environment. Such situations can be either deemed discrimination or fester into discrimination and therefore should be mitigated against. Harassment includes comments or actions that are unwelcome to you or should be known to be unwelcome. One has the right to be free from humiliating or offensive conduct that is based on one or more of the code's grounds. Harassment may require a course of conduct, which means a pattern of behavior or more than one incident. However, one incident may be enough to support a finding of harassment where the incident creates a poisoned environment. And now a poisoned environment is a form of discrimination and it can arise from even one incident. It may be created by comments or actions of any person regardless of their status. And these comments or conduct do not have to be directed to a particular person. The code prohibits the creation of such an environment. And an example of a poisoned environment would be ongoing jokes and comments or derogatory statements made about older persons in the workplace, which can then lead to the creation of a poisoned environment. Next, I hand it over back to Peter to discuss a case that demonstrates the working of the code.
Thank you, Austin. So we're now going to look at a real case, Perez and London Athletic Club, that came before the Human Rights Tribunal of Ontario. And this just illustrates the tribunal's expectations when it comes to considering and responding to requests for accommodation. So firstly, what happened? So the applicant was a customer service associate who worked behind the counter at the health club and developed swelling in her feet and pain in her legs due to her pregnancy. Her doctor provided a note saying that she should avoid prolonged standing and would benefit from being able to sit and stand alternatively. The applicant asked to be able to sit while servicing customers. However, the employer said that placing a stool behind the counter would be a safety issue. As the applicant did not know her right to be accommodated, she felt she had no choice but to ask for part-time hours. After the applicant contacted the Ministry of Labor and learned of her right to be accommodated, she requested reinstatement to full-time hours with accommodation from her employer. The request for full-time hours was denied by the employer, and the employer instead offered to allow her to sit at a table and do paperwork during her shifts, but this was only if it wasn't busy behind the counter. So what did the tribunal look at? The tribunal found that the employer had failed in its procedural duty to accommodate, as they took no steps to consider the medical note that the applicant had received from the doctor, discuss the applicant's accommodation needs, measure the space behind the counter, or test out a chair or a stool. With regard to the substantive duty to accommodate, the tribunal also expressed doubt as to whether any significant safety risk would have resulted from placing a stool behind the counter. The tribunal was also critical of the employer's refusal to consider returning the applicant to full-time hours once she had clearly asserted her right to accommodation. And so, as seen in this case, employers have a duty to accommodate. In this case, the employer failed the procedural duty as they did not thoroughly consider the request in the medical evidence, and the substantive duty as they did not provide the appropriate accommodation. In addition to paying the applicant compensation for the difference between their actual earnings that they had part-time and the amount they would have made had they been working full-time, the employer also had to pay the applicant monetary compensation for injury to dignity, feelings, and self-respect in the amount of $10,000. The tribunal found that the respondent's theory that the applicant regretted her completely voluntary request for reduced hours is a very unlikely explanation for the complaint. They accepted the applicant's explanation that she felt she had no alternative but to ask for reduced hours in order to preserve her health after the respondent ignored her request to be accommodated by being allowed to sit for some periods of time during her normal full-time working hours. So just because the employee took reduced hours did not excuse her from making a claim to the tribunal and receiving pay for full-time hours, as no duty to accommodate was provided. So our key takeaway from this is that the case highlights the risk that an employer may be ordered to compensate an employee where they have failed to adequately consider or provide for requested accommodation. I'll now pass it on to Bhavika, who will go over the Health and Safety Act.
So moving on to the Ontario Health and Safety Act, the purpose of this act is to The main purpose of this act is to protect workers from health and safety hazards on the job. It sets out duties for all workplace parties and also lays out the rights for workers. It established procedures for dealing with workplace hazards and provides for enforcement of the law where compliance has not been achieved voluntarily. So to explain what an occupational hazard is, it is a thing or a situation with the potential to harm a worker. It is important to note that a hazard only represents a potential to cause a harm. It does not necessarily need to actually cause the harm. Occupational hazards are divided into two categories: safety hazards that cause accidents that physically injure workers, and health hazards which result in the development of a disease. There is a three-step process for dealing with workplace hazards. First, it must be recognized. Recognition involves both identifying a hazard and determining if there is a possibility of workers being affected by it. If there is such a possibility, it must be assessed, and if it is found to be significant, then the hazard must be controlled. The Ontario Health and Safety Act applies to almost every worker, supervisor, employer in an Ontario workplace. This act does not apply to work done by the owner or occupant in a private residence. Section 25 of this act assigns a mixture of general duties, which are listed on the slide, as well as certain specific duties to employers according to the regulation. So like I said, some of the general requirements are listed on the screen. However, specific duties may vary depending on the type of business. Now, how it applies to diversity and inclusion. It is important to understand that the OHSA is an employer-facing, employee rights-based law, which means there is a strict liability and obligation on the employer. Employers and supervisors are required to address and acquaint workers of any hazards. Once adequate notice has been provided, it then becomes a personal liability on the employee to address their safety and the safety of others around them. However, based on the shared knowledge, the employee then also has the right to either participate in the work or refuse to work. In terms of diversity and inclusion, there can often be occasion when such rules may come into direct conflict with one's expression. Oftentimes, it could be their religious expression, so sometimes it could in conflict with the religious dress requirements. For example, certain religious beliefs do not permit men to cut their hair. However, certain workplaces may prefer to employ men with short hair, and this may this may result in constructive discrimination. At this point, the employer has a duty to accommodate short of any undue hardship. For health and safety reasons, an employer may ask employees to contain their hair in a net or other appropriate head covering, or maybe assign other roles. Clothing or gear with a health and safety rationale may also constitute a reasonable occupational requirement. Nevertheless, the employer still has an obligation to accommodate the employee. For example, by seeing if the gear can be modified to permit the person to wear their religious dress safely, or by examining whether the employee can assign different roles. When faced with such circumstances, you can consider some of these questions. So to begin with, what is the exact nature of their religious observance or their expression? What is the reason for the uniform or dress code? What measures can be taken to accommodate the person? Are there any alternatives available? And are there any health or safety factors involved? In some cases, clothing or gear with a health or safety rationale may constitute a bona fide requirement. Even where a dress requirement is found to be bona fide for health and safety reasons, the employer or service provider may still be obliged to seek to accommodate the employee. For example, as I mentioned earlier, the employee can potentially be transferred to another available job that does not require the clothing or gear. Failing to consistently apply health and safety standards, even when they are bona fide, when it is a bona fide requirement, by enforcing them for example, by enforcing them selectively in cases involving people with a creed or a certain religion, may result in the finding of discrimination. So how is this act enforced? The ministry's goal is for all workplaces to achieve self-compliance with this act and regulation through a well-functioning internal responsibility system. Where this does not happen, a progressive enforcement rules result. Enforcement begins with the issuing of orders and may proceed to prosecution. Inspectors are the enforcement arm of the Ministry of Labor. A prosecution may be initiated against anyone having duties mentioned in the Ontario Health and Safety Act, so as was mentioned earlier, which include the owners, suppliers, employers, and so on. So some examples of this, there are two prominent cases that came up discussing the conflict between one's expression as well as how it came into conflict with the Ontario Health and Safety Act. First was Singh versus Security and Investigation Services. In this case, a security company's policy requiring all security guards to wear a hat and be clean shaven was found to have discriminated against a turbaned Sikh man who wanted to work as a security guard with the company. In finding the company could have accommodated him without creating undue hardship, the Board of Inquiry, which is known as the Human Rights Tribunal of Ontario today, rejected the company's argument that members of the public would be uncomfortable with a bearded and turbaned security guard. Another prominent case was Saudi versus Oddmax. In this case, an employer was found to be within their right to ask a female employee if it was possible for her to wear a religiously acceptable form of hijab that was more consistent with the employer's dress code. Upon judicial review, the Ontario Divisional Court distinguished between clothing preferences based on style and those based squarely on creed, with the latter receiving human rights protection. So in this case, the fact that she wanted to wear a specific, for an employer to ask the employee to wear a hijab that was more consistent with the employer's dress code was found within the human rights protection. Moving on to the Accessibility for Ontarians with Disabilities Act of the AODA. The purpose of the AODA is to benefit all Ontarians by developing, implementing, and enforcing accessibility standards in order to achieve accessibility for Ontarians with disabilities. It also provides for the involvement of persons with disabilities in multiple areas of practice. The standards help organizations to prevent or remove barriers that limit the things that people with disabilities can do, the places that they can go, and the attitudes of service providers towards them. The standards of the AODA give all people an equal footing as they work, play, learn, teach, buy, sell, and use their diverse talents to benefit the community. So who is a person with a disability? The definition of disability under the AODA is the same as the definition of disability in the Ontario Human Rights Code. So just to reiterate, disability means any degree of physical disability, infirmity, malformation, or disfigurement that is caused by bodily injury, birth defect, or illness. Now, it's important to understand that the AODA complements, not supersedes, the requirement for accessibility and accommodations that were described under the Ontario Human Rights Code. The AODA imposes different standards on public entities, large and small businesses. So the AODA is made up of 5 standards, as well as some general requirements, and these include the customer service standards, the information and communication standards, employment standard, transportation standards, and design of public spaces standards. These standards require organizations to create policies and practices that identify, remove, and prevent barriers for people with disabilities. The AODA stands on 4 basic principles, which include dignity, independence, integration, and equal opportunities. Speaking more on equal opportunity, it means having the same chances, options, benefits, and results as other people. In the case of services, it means that people with disabilities have the same opportunity to benefit from the way you provide goods or services as others. They should not have to make significantly more effort to access or obtain the services. They should also not have to accept lesser quality or more inconvenience. Being accessible to customers with disability isn't just the right thing to do, it's also the law. Under the customer service standard, businesses must train staff about serving customers with disabilities. The training must be provided to everyone who deals with members of the public or other third parties, for example, other business clients, as well as training your employees who develop these customer service policies. Organizations must have a process to also receive feedback and let people know how they will respond to feedback and take action regarding any complaints. So what requirements apply to all providers? So all providers, all businesses must establish policies, practices, and procedures on providing goods or services to help people with disabilities. It also involves setting a policy on allowing people to use their own personal assistive devices to access goods and services, use reasonable efforts to ensure that policies, practices, and procedures are consistent with the 4 core principles discussed earlier. Communicate with a person with a disability in a manner that takes into account their disability. It also involves training staff, volunteers, contractors, and any other person who interacts with the public or are involved in the developing of the policies to understand these customer service standards. Like, as I mentioned earlier, there are different responsibilities, there are different regulations for the type of business. So there's different for public service, for public employees, public sector employees, for small businesses and large businesses. If you are a designated public sector organization or a provider with 20 or more employees, in addition to the requirements that were listed earlier, you must also document in writing all your policies, practices, and procedures for providing accessible customer service and meet other document requirements set out in the standard. You must also notify customers the documents required under the customer service standards are available upon request. And when giving documents required under the customer service standard to a person with disabilities, you must be able to provide the information in a format that takes into account their disability. So information like public notices or emergency information must be provided in an accessible format. It must provide the information in a timely manner because it would simply not be realistic to provide information in an accessible format on demand. However, organizations must also provide or arrange accessible formats and communication support when providing information to a person with disability. These accessible formats are ways of presenting printed, written, or visual materials so that people with print disabilities can access them. For instance, these formats could include braille writing, large prints, accessible digital files, audio, text transcripts of visual or audio information. The employment standard would be discussed further when we talk about the Employment Standards Act. However, an applicant can request accommodation for the interview and any tests that might need to be completed as part of the application, and it must be provided. Organizations are required to accommodate employees with disabilities throughout their employment, whether it's modified duties, change to workstations, or assistive devices. The right to accommodation is not absolute. An employee can request support necessary, but the right to receive that accommodation is modified by the Ontario Human Rights Code, which states that accommodations are required to the point of undue hardship, as was discussed earlier. The transportation standard requires transportation companies to inform the public about accessible equipment and features on their vehicles, routes, and services. Now, the design of public space describes ways to make communal spaces more accessible. Most of the spaces it covers are outdoors. How is it enforced? There is an overlap between the type of events that would breach the AODA as well as the Human Rights Code. So a failure to administer the AODA could result in an Ontario Human Rights Code complaint to the tribunal. Some individuals often use the tribunal to enforce the AODA by filing applications alleging discrimination on the basis of their disability. The AODA gives government authority to set monetary penalties to enforce compliance with accessibility standards. The maximum penalty under the AODA include towards a corporation or an organization that is guilty can be fined up to $100,000 per day. A director or an officer of the corporation or the organization guilty can be fined up to $50,000 per day. So an example of this, of how the AODA, a case example would be the ADGA versus Lane. So some facts about this case: the complainant had been diagnosed with bipolar disorder. She applied for a job as a software program tester with the company. She was hired, and several days after he began the job, complainant began exhibiting manic behavior. 10 days after he was hired, complainant was terminated. Complainant made a successful human rights complaint. At this point, the tribunal found that the company discriminated against complainant on basis of their disability in terminating employment, and company failed to establish that it could not accommodate the disability without an undue hardship. Was the tribunal's finding of the discrimination reasonable? Well, the disability cases bring with them particular and individualized situations. Once it is established the termination of the employee was because of, or in part because of disability, the claimant has already established a prima facie case of discrimination. The onus then shifts to the employer to establish that it met its duty of procedural and substantive fairness to the point of undue hardship. Lane was under no obligation to discuss his disability, nor indeed his record of any sick days. The tribunal held as a fact that he did not misrepresent his ability to perform the task and tasks required of him. The tribunal held as a fact that he was terminated because of his disability. So was the finding of the tribunal that the ADGA failed both the procedural and substantive duties to accommodate reasonable? As was mentioned earlier, employers have procedural and substantive duties to accommodate employees with disabilities up to the point of undue hardship. The onus is on the employer to establish that it has met these duties, The procedural duty to accommodate involves obtaining all relevant information about the employee's disability, at least where it is readily available. It could include information about the employee's current medical condition, prognosis for recovery, ability to perform job duties, and capabilities for alternate work. The term undue hardship requires respondents in human rights cases to seriously consider how complainants could be accommodated. A failure to give any thought or consideration to the issue of accommodation, including what, if any, steps could be taken, constitutes a failure to satisfy the procedural duty to accommodate. The procedural dimensions of the duty to accommodate require those responsible to engage in a fuller exploration of the nature of the bipolar disorder and to form a better informed prognosis of the likely impact of his condition towards his workplace. The substantive duty to accommodate requires the employer to show that it could not have accommodated the employee's disability short of undue hardship. Undue hardship cannot be established by simply relying on impressionistic or anecdotal evidence or after-the-fact justification. While common sense and intuitive reasoning may be utilized by an employer, in a case where accommodation is refused, there must be some evidence to link the outright refusal of even the possibility of accommodation with an undue safety risk. The ADGA had to show that it was not impossible to accommodate Lane without risking reasonable safety. The ADGA did not provide any independent or expert evidence to establish that it would be impossible for them to accommodate Lane's disability without the undue hardship. Therefore, ADGA was held to be guilty by the HRTO. Now moving to Nicole to discuss COVID-19 and its impacts.
Perfect. Thank you so much, Bhavika. So moving on to COVID-19 and what employers need to know. The COVID situation is changing rapidly and should be treated accordingly. What is correct now may not be correct tomorrow, which is important to know. Ontario also has experienced the most cases of COVID-19 and consequently has introduced the most expansive measures to combat the virus. I will discuss employer obligations generally across Canada, but also with a special focus on Ontario specifically. Some important legal framework to consider includes the Employment Standards Act, which deals with statutory leaves of absences, the Emergency Management and Civil Protection Act, which deals with declared emergency leaves, as well as the Workplace Safety and Insurance Act, which focuses on eligible workers who are able to claim benefits where they contracted COVID-19 in the course of performing their employment duties. The Employment Insurance Act, which also deals with and focuses on workers who experience a reduction in normal weekly earnings of at least 40% due to illness, injury, or quarantine, are eligible for EI sickness benefits. The Occupational Health and Safety Act, which focuses on employee work refusals as well as employers' obligations to ensure a safe workplace. Last but not least, the Human Rights Code as well, which also has a duty to accommodate for medical reasons related to COVID-19 vaccine mandates, as well as proof of vaccine certificates. Employees who contract COVID and as well as employer obligations, if a worker shows symptoms of a respiratory illness, they should be encouraged to remain at home and in isolation and contact their healthcare provider. Telehealth Ontario at 1-866-797-0000, as well as report to their local public health unit. The employer is required to take every reasonable precaution in the circumstance to protect the health and safety of workers, and also do a risk assessment to determine what parts of the job site and also what other workers the affected worker would have had contact with. There is also a process for businesses covered by the WSIB for reporting workplace illnesses, and more information can be located and obtained from the WSIB link below. PPE equipment and concerns with it. If you have a workplace health and safety concern about personal protective equipment, such as use of masks, because they are, for example, absent or have a defect that puts you or another coworker at risk, you must report your concerns to your supervisor or employer. Questions about the voluntary use of such equipment should also be directed to your employer or supervisor. You should also raise the issues or concerns with your joint health and safety committee or your health and safety representative in your workplace. COVID-19 mandates as well as proof of vaccination. The goal of Ontario's COVID-19 vaccination plan is for everyone in Ontario to be able to get a vaccination if they choose to do so. Workers who are considered employees under the ESA have the right to take job-protected infectious disease emergency leave if they need to take time off work to get vaccinated or because of the side effects for after the vaccination. An employer cannot penalize an employee in any way for taking or planning on taking an infectious disease emergency leave. Many businesses have questions about mandatory vaccination policies. Whether an employer can require vaccination by policy is still a very much developing topic and very context specific. Early decision in the labor arbitration context are mixed and generally tied to the sensitivity of the workplace. Employers with questions about implementing policies should seek specific legal advice. Business shutdowns and work refusals. When it comes to voluntary as well as involuntary layoffs, employers can consider temporary layoffs. The ESA's rules around temporary layoffs, which previously permitted 13 weeks in a consecutive 20-week period in Ontario, have been amended by emergency legislation introduced as a result of the COVID-19 pandemic. In addition, any specific questions about layoffs during the COVID-19 period should be referred to a lawyer. You can see for more information down below at the link. So some work refusals. Under the Occupational Health and Safety Act, most employees have the right to refuse work if a condition of the workplace is likely to endanger their health or risk their safety. However, refusing to attend work because it would require them to interact and be around people who have recently traveled to an affected area is not a legitimate work refusal. The OHSA imposes obligations to investigate the refusal, and if not resolved at that certain stage, to report to an inspector. Kingston has a ministry field branch, so that is where you would generally report to. Termination of employment. Generally and subject to the terms of any individual contract of employment, employers have the right to terminate an individual's employment without cause in the event of an economic slowdown. Employees who are terminated without cause are entitled to receive any statutory termination and or severance pay as well as benefits owing, and may also be entitled to common law notice. And now I pass it on to Charlotte.
Thank you. So for the purpose of this presentation, although the Employment Standard Act covers a wide variety of topics, I'll be focusing on pregnancy and parental leave, as well as equal pay for equal work. So the purpose of the Employment Standards Act is that the Act sets down a minimum standards for basic conditions of employment, including wages, leaves of absences, work hours, overtime, and notice and severance pay obligations upon termination. It also lays out the legal rights and duties of employers and employees. So who the Act applies to. So the Act covers most Ontario employees with the exception of federal employees, police officers, co-op students, among others. The Ministry of Labor enforces the ESA and its regulations, provides information, investigates potential violations, and resolves complaints. So the Employment Standards Act and parental leave. So during pregnancy and parental leave, the ESA protects the employee's right to continue to take part in employer benefit plans. The employee's leave period is to be included in any calculations of the employee's length of employment, length of service, or seniority. At the end of the leave, the employee must be reinstated to the position he or she most recently held with the employer, or if the position no longer exists, a comparable position, unless the person's employment has been terminated for reasons unrelated to the leave. An employer cannot refuse to give the employee her job back because it prefers the person who was hired to replace her during her leave. Note that the ESA prohibits employers from intimidating, dismissing, or otherwise penalizing an employee because he or she is or will become eligible to take a leave, intends to take a leave, or takes a leave under the Act. So as far as parental leave, the term parent includes a birth parent and adoptive parent, whether or not the adoption has been legally finalized, or a person who is in some sort of permanent relationship with a parent of the child and who plans on treating the child as his or her own. This does include same-sex couples. So the rights for employees taking pregnancy and parental leaves. To reiterate, employees on pregnancy or parental leave have the right to reinstatement. In most cases, an employee who takes a pregnancy or parental leave is entitled to the same job the employee had before the leave, or a comparable job if the employee's old job no longer exists. Employers who violate the ESA can be ordered to comply. They can be ordered to pay their employees, ordered to pay a penalty, or prosecuted. Under the ESA, an employer cannot punish an employee in any way for asking the employee about their rates of pay to find out if an employer is providing equal pay for equal work, or disclosing their own rate to pay another employee for the purpose of determining or assisting that employee in determining whether he or she are receiving equal pay for equal work. So an employer cannot pay one employee at a rate of pay less than another employee on the basis of sex when they perform substantially the same kind of work in the same establishment, their work requires substantially the same skill, effort, and responsibility, and their work is performed under similar working conditions. This standard is commonly referred to as equal pay for equal work. Again, employers cannot lower employees' rates of pay to create equal pay for equal work. For context, before getting more into this topic, it is important to note that not all differential treatment is discrimination. A discrimination claim for being paid less than a male coworker will be dismissed if there is no proven nexus between the applicant's gender and the difference in pay. Gender must be a factor in the adverse effects suffered, although it does not need to be the only factor, and there is no requirement to prove an intention to discriminate. The work performed does not have to be identical, but a substantial difference in any one of these criteria could justify a difference in pay. Equal pay for equal work exceptions. So the references to seniority, merit, and measurement systems have been interpreted as requiring formal, objective, documented systems which are gender neutral and applied equally to both sexes. The day-to-day impressions or opinions that a manager forms of workers are not sufficient. So next, I'm going to be talking about the Pay Equity Act. So the key here is to understand that this act deals with establishing equity between comparable male and female job classes. The act does not deal with an individual, nor does it propose a comparison between individual employees. The stated purpose of the act is to redress systematic gender discrimination and compensation for work performed by female job classes. The act is concerned with reducing the gender pay gap by addressing the influence of societal biases which have historically undervalued women's work and skewed the wage setting process. Unlike other regimes, the Pay Equities Act focuses on groups of women workers rather than on individuals. It is not principally a complaints-based system. Rather, it is affirmative action legislation that imposes certain protective measures on employers to identify and eliminate gender-based wage discrimination in their workplace. What the Pay Equity Act is not. Again, evaluating individuals or their performance on the job, internal equity or fairness pay among classes and individual employees, comparisons between two different female job classes, for example, receptionist and secretary, or two different male job classes, for example, a mechanic or a welder. Comparisons of female and male job classes between different employees, and setting wages according to market rates of pay. Women, men, and male job classes or gender neutral job classes do not have entitlement under the Act. Equal pay for same work, which means that if a man and woman are doing substantially the same work, for example, a sales job in a department store, they must receive the same pay. Equal pay for equal work falls under Ontario's Employment Standards Act. So what does job classes mean? So female job classes means, except where there has been a decision that a job class is a male job class as directed in Clause B of the definition. A job class which 60% or more of the members are female. A job class that a review officer of the hearings tribunal decides is a female job class, or a job class that the employer, with the agreement of the bargaining agent, if any, for the employers or the employees, decides is a female job class. Job class means those positions in an establishment that have similar duties and responsibilities and require similar qualifications, are filled by similar recruiting procedures, or have the same compensation schedule, salary grade, or range of salary rates. So who does this apply to? The Act applies to all employers in the private sector in Ontario who employ 10 or more employees, all employers in the public sector, the employees of employers who work for this Act applies, and their bargaining agents, if any. So similar to the Employment Standards Act, this Act does not apply so as to prevent differences in compensation between a female job class and a male job class if the employer is able to show the difference is the result of a formal seniority system that does not discriminate on the basis of gender, a temporary employee training or development assignment that is equally available to male and female employees and that leads to career advancement for those involved in the program, a merit compensation plan that is based on formal performance ratings and that has been brought to the attention of the employer, of the employees that does not discriminate on the basis of gender, the personal practice known as red circling, where based on gender neutral reevaluation process, the value of a position has been downgraded and the compensation of the incumbent employee has been frozen, or his or her increase in compensation has been curtailed into compensation for the downgraded position is equivalent to or greater than the compensation payable to the incumbent, or a skill shortage that is causing a temporary inflation in compensation because the employer is encountering difficulties in recruiting employees with the requisite skills for positions in the job class. And lastly, here are key takeaways from all the legislation and acts that we went over. So again, for the OHRC, accommodation to the point of undue hardship. Under the OHSA, accommodation can and must be provided without compromising the health and safety of the workforce. Under the AODA, accommodate according to the needs of the person with a disability. The Pay Equity Act is equal pay for work of equal value. The ESA is equal pay for equal work. And again, it sets out the minimum standard requirements. In COVID-19, as we know, they're constantly changing legislation, so that is something to be mindful of. And finally, thank you for listening to our presentation. It was incredibly appreciated and we were happy to be here. And lastly, if you could please fill out our client impact survey. Knowing more about who accesses these services of PBSC helps us assess our program. This information you provide is on the survey will remain anonymous. Also, please note that this form is implemented on a national level and therefore not all the questions may apply to your situation. Again, please answer the questions that apply to you to the best of your ability. And thank you.
Wonderful. Well, thank you guys so much for speaking with the membership today. We're grateful for the time and effort that you took to share all of your research and thoughts with us. Everyone, I thought, did a fantastic job. So now we'll be opening the floor to anyone who has a question. If you'd like to ask a question, please feel free to just unmute yourself and ask it, or you can type it in the chat or send me a private message, whatever is easier. Now, I will say that this presentation is being recorded, so if your preference is to ask in an offline format, please just send me an email and I'd be happy to forward that to Bhavika and her team, and we'll get back to you with a response. Just gonna scan here. Looks like we've got a quiet group this morning.
And
that or you guys answered everything.
I was going to say, it was so well prepared and well planned and executed. I don't think you left any gaps for people to ask questions. I think you've covered so much.
Amazing.
And great detailed slides too. So it's a great takeaway for the group and for the membership.
Yes, I was just going to reiterate for everyone on the call today, we will be sending out a copy of the presentation along with the recording so that you can share with your teams and your networks as well. But if there aren't any questions, I'm just going to check one more time. No, okay, perfect. Well, in that case, we'll wrap up a couple minutes early. Thanks again for everyone who attended today's session. We hope to see you at our next Pro Bono Student Council presentation titled Insolvency, and that will be happening on Tuesday, March 29th at 8:30 a.m. So thank you again to our attendees and presenters, and I hope everybody enjoys the rest of their day.
Thank you, Jessica and Karen. And like you mentioned, if there are any questions, feel free to send it our way and we'll try our best to answer it.
Amazing. Take care, guys.
Thank you.